this video, I'm going to answer the question, what are the implications for a company when a director dies? Now, the loss of a loved one is not only very distressing, but it can also have a material impact on whether the business can continue trading or not. For example, if there's no succession plan in place, then the worst case scenario is that the business will be liquidated and the assets forfeited to the government, which I'm sure nobody wants. To safeguard against this, a little bit of planning and proactive decision making is required from you. To be clear, this video covers private companies specifically, but please be aware that there are a multitude of other formal business entities such as NPCs, trusts, closed corporations, as well as informal, such as partnerships and sole proprietors. Each one of these business types will have specific legal procedures and requirements to manage the death of a director, trustee, member, or partner, but the broad principles remain similar to that of a company. When any individual dies, a number of actions are required to wind up the person's estate. So within 14 days of the death of an individual, an interested person must report the estate to the master's office in the jurisdiction where the individual lived. If the value of the estate exceeds 250,000 Rand, then a letter of curatorship must be issued and the Administration of Estate Act followed to wind up the estate. For estates with a value less than 250,000 Rand, only a letter of authority is required. If the will of the deceased does not name an executor in their estate, the court will appoint one. So to ensure that the executor of your choice is appointed, it is essential that a will is up to date and includes the nomination of the executor of your choice. I've left a link in the description should you need any assistance in drafting a free will. Please be aware that in South Africa, the power of attorney lapses on death and it is therefore not viable nor legal. Since this video is about how companies manage succession with a deceased director, we'll get right into the detail. For this purpose, there are three possible scenarios for companies and directors and shareholders, namely companies with multiple directors, companies with one director but multiple shareholders, or companies with one director who is also the sole shareholder. In the first scenario, multiple directors, the day-to-day running of the business simply continues and the remaining directors pick up the duties of the deceased director. If the deceased director is also a shareholder, then the shares fall into the estate and will be paid out according to the wishes set out in the will. But be warned, getting a fair price for the shares in a private company can be a tricky business. For example, the company may not have the funds available to buy the deceased shares. So to cover this risk, many companies take out key man insurance policies to fund the buyout. Another issue might be that the remaining shareholders may not want to pay the asking price, especially if the process of valuing the shares were not agreed upon upfront. So a well-drafted shareholders agreement should resolve such a dispute, as it will set out the process of valuing the shares in such an event. The remaining directors would need to update the directors register by removing the deceased from the directors register on the CIPC database. This requires a death certificate, a letter of curatorship, ID, and signatures of the executor and the ID of the deceased. Now, assuming a standard MOI is used for the company, then the remaining directors can appoint a new director should they so wish. In the second scenario, the company has only one director but multiple shareholders. Since the company is required by law to have a minimum of one director at all times, a new director must be appointed as soon as possible to ensure the continuity of the business. Assuming the company has the standard MOI and no amendments have been made to the voting rights of the shareholders, their votes are based on equal rights and not on the percentage of ownership, which effectively means that each shareholder has equal voting rights regardless of how many shares they own. So, as long as 50% of the shareholders are in agreement, the resolution will pass and the new director can be appointed. In the third scenario, the company only has one director who is also the sole shareholder. This is the most precarious of all the scenarios. Upon the death of the sole director, the personal bank accounts are immediately frozen, while the business bank account becomes restricted, effectively only allowing deposits. This means that employees won't get paid and bills won't be settled, which is all very stressful. To make matters worse, if there's no will and no relatives, the company will be liquidated and the assets forfeited to the state, a scenario best avoided. The problems are compounded by the fact that the master's office can take months to appoint the executor, during which time the business can flounder, which could lead to financial difficulties and destruction of value of the company. So I urge you to plan to ensure that your company can continue operating after you have died and before the executor has been appointed. For example, you can appoint a trusted family member as an authorized signatory to the company. This will ensure that the business bank account can operate unhindered after your death. If the business is more complex and requires regular management decisions to be made, it would be wise to appoint a second director on the company, or at least have an application ready to appoint a capable person, perhaps your accountant, who is willing to act as a new director in the event of your death. So, in conclusion, I would recommend the following. All sole directors take steps to ensure continuity of their business upon their death. All companies with multiple shareholders should have a shareholders agreement, and everyone should have an up-to-date will. I hope you found this video informative. So as always, remember, we are here to help.